All right, so can we search a stolen motor vehicle as a matter of routine? All right, that's a good question. So my name is Anthony Bandiero, attorney and senior legal instructor for Blue 2 Gold Law Enforcement Training, bringing the roadside chat. This question comes from an officer in New Mexico. And the officer says, hey, look, we recover stolen vehicles. Sometimes they're dumped. Sometimes they're occupied. It seems to be a standard to search the vehicle upon recovery. So my question is what is the reason for searching the vehicle upon recovery? And what is our legal basis for doing so? I know the vehicle thief doesn't have an expectation of privacy. That is true, right? But what about the vehicle owner? I guess you present, or you can imagine a situation where we recover the vehicle and we start searching it, and we find evidence that we use against the vehicle owner. Let's say we find child porn in the center console, or maybe like a glove box, and you just do not believe under the facts of the case that the thief had anything to do with that. In fact, let's actually even better. Let's say that the pictures are of the vehicle owner with a child. What now? How do we get this evidence in? It is a good question. So let me answer it. There's a few things going on here. Number one is obviously we may be doing inventory, right? That the vehicle is going to be taken into our custody. 99% of agencies are going to do a vehicle inventory on that. So that may be one way to get into the vehicle lawfully. The other one, though, is probable cause, right? I'm of the position, generally speaking, that it's very easy to argue probable cause in these situations. You have a thief, right? Or let's say the vehicle has been dumped. Do you think that there may be evidence in there of who took the car? Maybe somebody dropped their wallet. Maybe you're going to do some evidence collection, like DNA or fingerprints. Depends on how serious the crime is. But is there a probability that there may be some left behind evidence in there? I think the answer is yes, right? Even if it's occupied, is there going to be indicia of control and intent? Is there going to be potentially a backpack in there where burglary tools are in there, shaved keys, pry bars, all this pry tools and so forth? I think the answer is yes. Maybe some other evidence that the person has been stealing cars, like stuff from other vehicle burglaries. Maybe they have credit cards with a name on there, and you run that name, and sure enough, they had their car stolen 2 weeks prior, stuff like that. So that also pins them on prior history of stolen vehicles. I don't know, but the point is I think, generally speaking, even if we're going to let this car go, right? Even if the owner shows up and says, hey, I want my car back, let's say we're not going to tow it, I still think that most cops are going to be able to articulate that they have at least probable cause. There's a fair probability that there's evidence of the crime in that vehicle, and we want to search it. Should you get a warrant? Sure, that's always going to be better, right? In many situations. Now, actually, speaking of which, New Mexico is more strict on vehicle searches without a warrant, so we got to be careful there. They usually require exigency to search with probable cause, but then I guess they get saved by the no standing issue, no privacy interest. So there's my feedback. I think it is a good question. I don't think it's a slam dunk. I don't think I would be lying to you if I said, hey, yeah, you can search them as a matter of routine. This officer is onto something here. I just don't think it's very hard to do. All right. Hope it helps. If you have more questions, reach out to us at blue2gold.com/show. Don't forget that we have weekly webinars, when we talk about search and seizure issues. So hopefully I'll see you there. And until next time, my friends, stay safe.